highly useful individual. Okay. Okay, so
I don't know why that happened.
yeah, well, there you go. So that's Jacob. Go ahead, Stephanie.
Perfect. And Jacob and Samia, thank you so much for coming back again. I think as we were chatting already, I know this has been really valuable to people that have joined kind of some hot topics. So Samia, thank you so much again. And she practices law focused on the representation of management in many areas of employment and labor law, with particular emphasis on employment law, employment agreements, policy development and implementation, human rights, and accommodation in all matters related to accessibility for Ontarians with Disabilities Act. That's a long list. Was going to run out of breath there. So thank you so much again for both of you being here, and we're looking forward to everything you have to share.
Awesome. Thank you very much, Stephanie and Gord. And thank you to the Clarington Board of Trade for inviting us this morning. As mentioned, we are speaking on the topic of managing disabilities in the workplace. So both Jacob and I are lawyers with the firm of Shared Coos, and as mentioned, we are labor and employment lawyers, and we practice in pretty much every area of labor and employment law. And so I'll now turn it to my colleague Jacob to lead the discussion.
Great, thanks, Samia, and good morning, everyone. Thank you for joining us today. So we're going to jump right in with the agenda. And so today we're going to be starting with an overview of an employer's disability accommodation obligations. We will then be discussing relevant considerations about medical information and gathering medical information. And then we'll conclude with a discussion on best practices for accommodating disabilities. So we'll get started now on disability accommodation. And the starting point of the discussion about accommodating disability is the relevant legislation. Now, there are a few primary statutes that impact this discussion. So the first is the Human Rights Code, which protects against discrimination on a number of protected grounds, which include disability. An employer's failure to comply with the code can result in costly damages awards and other negative impacts in the workplace, including bad publicity, employee morale, etc. Now, there are numerous decisions in which the Human Rights Tribunal has awarded damages for mental health disabilities and how they were treated in the workplace. And an employer will also bear significant risk from a financial perspective where it fails to adhere to the legislative requirements related to accommodation. Examples of damages awarded by the Human Rights Tribunal for failure to accommodate include a decision where they awarded over $30,000 to an employee who was terminated after being absent from work for only 2 days due to anxiety and depression. $58,000 damages award to an applicant who successfully alleged his anxiety and the necessary absences from work associated with this condition were factors in the employer's decision to terminate his employment. And another decision in which $80,000 was awarded to an individual who was terminated shortly after disclosing that he had bipolar disorder. So these are just a few examples that show the importance of accommodating disability in the workplace and the potential liability associated with failing to do so. So the AODA is another statute that is relevant to accommodating disability. And the purpose of that act is to create, implement, and enforce accessibility standards that organizations from public, private, and nonprofit sectors must follow. And in some situations, employers are even required to develop written accommodation policies and return to work plans for individuals who require accommodation. Under the AODA, the ministry may also issue penalties for noncompliance, and in extreme cases, an employer may be convicted of an offense under the legislation. Another important statute that deals with accommodating disability is the Workplace Safety and Insurance Act. The WSIA provides for benefits for an individual that suffers from a variety of disabilities, including psychological conditions as well. So as you can see on the slide, entitlement under the WSIA changed January 1st, 2018. And following that date, an individual may be entitled to benefits for what's known as chronic mental stress, where the worker was diagnosed with a mental stress injury and the predominant cause was a substantial work-related stressor. So in terms of appropriate diagnoses, you'll see that reference there. These are made under the current version of the Diagnosis and Statistics Manual of Mental Disorders, or the DSM. And in this case, they may include acute stress disorder, post-traumatic stress disorder, adjustment disorders, and anxiety or depression disorders, and a variety of others as well. And diagnosis must be made by an appropriate regulated healthcare professional. And this includes doctors, nurse practitioners, psychologists, psychiatrists, and those kinds of things. And in terms of a substantial work-related stressor, this may be a single work-related stressor, multiple stressors, or a series of stressors. And the worker must identify specific events that were alleged to have caused the chronic mental stress. It will be considered substantial if it is excessive in intensity and or duration in comparison to the normal pressures and tensions experienced by workers in similar circumstances. And this can also include workplace harassment. So under the Human Rights Code, disability is broadly defined. It includes a number of elements, including physical, mental, invisible, temporary and episodic. And these are important to keep in mind when we're discussing accommodating disability in the workplace. So the duty to accommodate a disability does not only apply where an employer knows about a disability. The duty to accommodate actually also applies where an employer should have known about the disability. And in certain circumstances, an employer has a duty to inquire. And this is where the employer has reason to believe on an objective standard that an employee's actions or conduct that may otherwise warrant discipline or termination of employment may derive from a disability. Now, the duty to inquire is generally linked to an understanding that an employee may have a difficulty in disclosing a medical condition for privacy reasons or for fear of stigma. As well, because of the nature of mental disability, the employee themselves may not be fully aware of the fact that he or she is exhibiting a certain behavior or has a disability at all. This is part of the reason for why there exists a duty to inquire. And in other situations of human rights accommodation, for example, religious or family status accommodation, a lack of awareness and stigma issues are not present to the same extent. Therefore, we have not seen the duty to inquire generally apply to other particular groups as well. And instead, it focuses on primarily on disability. So the case law is clear that an employer does not need to be an expert to identify that an employee is struggling with a disability. Now, in this quote, the quote on the slide identifies that it's an objective standard that is applied to the duty to inquire. And as you can see by the bolded and underlined spot, it says some things are so obvious that one does not need to be an expert to figure them out. So there are a number of situations in which the duty to inquire may be triggered. And these include where there's a marked departure from the employee's normal workplace conduct. The employee previously disclosed a disability and has recently demonstrated a similar behavior, or there is other evidence pointing to a disability, for example, the smell of alcohol on an employee's breath. So some examples of the type of behavior that may trigger a further inquiry include unusually sensitive or emotional behavior, unusually angry or aggressive behavior, acting in a way that is different from an employee's normal personality, unable to organize oneself, having difficulty focusing or concentrating, and erratically yet persistently being absent. And the common thread among these examples is that the behavior is simply unusual. Behavioral changes such as these do not necessarily mean that an employee has a mental illness, and the employee may simply be having a bad day or going through a stressful time in his or her personal life. But when this pattern of behavior continues for a prolonged period of time, it may be indicative of an underlying health problem. And in many cases, the duty to inquire may be also triggered by workplace rumors or other employees coming to management to advise of what they've heard or seen. An employer may need to address these rumors proactively with the employee, particularly if they coincide with changes in the employee's performance or conduct in the workplace, or if the disability could pose a risk to health and safety. While the usual course of action may be to discipline an employee, the duty to inquire requires an employer to first meet with the employee to discuss whether there may in fact be an underlying disability. This step must be undertaken before an otherwise culpable conduct is treated as such by the employer. And a failure to inquire may be found to be a breach of the duty to accommodate. If a disability is suspected, meeting with the employee privately may be an important first step. So it's important to come prepared for this type of meeting and to approach the concern as a workplace performance issue. You would want to outline your concerns with the employee and review and discuss your workplace policies and raise the possibility of providing accommodation if necessary. It would also be prudent to identify and discuss available resources that the individual can access. And this may include employee assistance programs or referral to community services. It's also important that the meeting is fully documented and that you set aside time to meet again with the individual to review their performance. An employer should avoid trying to give a name to the underlying issue. And even if you suspect a particular illness or problem may be the cause, focus on the employee's behavior that is concerning you and how you want to help them improve. If the employee discloses a disability, avoid asking what caused the illness, but instead focus on next steps, like the collection of medical information, potential accommodation, etc.
Great. So I'll now discuss what the latter part of what Jacob mentioned, the issues around obtaining medical information. So when it comes to obtaining medical information, I think this is an area in which employers have an opportunity to do more. Oftentimes, employers are provided with letters from or notes from employees that simply state sort of 2 lines. Worker can't come in, will be off for 3 months. And oftentimes we're stuck with the question of, well, can we ask for more? What can we ask for? And I think our firm and Jacob, I know, would agree that we can use those moments as an opportunity to obtain additional information from the employee in order to facilitate our obligations to accommodate them. So the employer has a right to obtain that relevant information. And that ability to collect that information oftentimes is challenged by some employees. And what we sort of say is the obligation, the duty to accommodate is a 2-part process, right? It's the employer and it's the employee. And if you're in a unionized context, the union is also involved. So the employee and their union, if they're present, have an obligation to participate in that process, which includes providing appropriate medical information. So what does that mean? So the employer is entitled to receive sufficient medical information to satisfy their duty to accommodate. So that includes details around what the limitations and the restrictions of their injury happens or their disability happens to be. Typically employers aren't entitled to receive a diagnosis. So we're not entitled to receive a diagnosis of depression, anxiety. And what I often say is that's not helpful to employers in any case, because we're not medical professionals. It's difficult for us to know, in fact, what can that employee do and not do. So what you should be obtaining is a robust list of limitations and restrictions. So one way of dealing with that is employers have functional abilities forms that set out physical restrictions, so how much the person can lift, how much they can carry, how much they can, whether they need to walk, or limitations on sitting, that type of thing. But it can also include limitations on cognitive abilities. So what level of stress can the person handle? How do they need breaks in order to deal with some mental health related issues that may result from their position? That information is something an employer is entitled to. And when you receive a request to accommodate, if you don't have that information, the first step for an employer is to get that. So the strategy there is to provide an employee with a letter that they can provide to their doctor or their medical professional outlining what questions the employer needs answered in order to accommodate them. Most employers will pay for that assessment because it's being requested from them, and the questions being asked are often detailed, so it can be a bit costly. So some employers offer a reimbursement of $50, $100 or something of that nature. The information that is provided by a medical professional is oftentimes insufficient. So what needs to happen is a bit of a back and forth. So you receive that medical note, it's insufficient, you ask for clarifying questions, and then sometimes you may get a doctor who refuses to answer some of the questions or doesn't answer, and sort of provides you with the information that you didn't ask for. In those circumstances where you're struggling to even obtain the information requested, there are some options that an employer can use. And we'll talk about that in the next slide, but you can look at acquiring a third-party review or a potential IME, an independent medical examination. For both of those steps, the employee must consent, so they have to be a willing participant in that process. In terms of the third-party review, that's where a doctor or specialist medical professional is obtained by the employer to provide consultation to the employer on what the employee can do. So we hire a third-party medical reviewer, they connect with the employee's medical professional, and then we receive information from our third-party reviewer around, well, what can that employee do? When is their expected return to work? And the benefit there is it's, first of all, it's less intrusive and less expensive than an IME, but it also gives you an opportunity to get objective medical information. So if you're in a situation where the employee is providing you with medical notes that really look more like advocate notes, so the doctor is sort of, including information about the individual's coworkers and making statements about what specific accommodation requests are required. If you're finding that you're not actually getting the limitations and restrictions, and you're going through with the back and forth, a third-party review is a step in the process that can actually provide a lot of clarity and give you, as the employer, the information that you need around limitations and restrictions. If a third-party review is unhelpful or perhaps you're dealing with conflicting medical, you can look at potentially using an independent medical exam, an IME. That's typically considered a last resort, and that's because of the privacy concerns, and it's also a very intrusive process. The employee has to actually undergo a review, whereas with the third-party medical review that I talked about on the previous slide, the employee not having to submit an examination or merely just having their doctor contacted. Whereas with the IME, it requires a lot more of an invasive process for the employee. But that being said, there are some cases where it's appropriate. And again, that's where perhaps you're dealing with conflicting medical. So an employee has provided you with medical notes that are completely inconsistent, or you keep getting patient advocate notes that don't give you the information that you need. Or alternatively, you're a bit suspicious of the information that you're getting. If the employee consents, you can look at using an IME to help facilitate that process and manage how you can accommodate them in the workplace. So the case on the slide provides a good example of obtaining medical information. So the employee in this situation had a high degree of absenteeism. They were terminated because they were absent without leave. So in that situation, there was a deemed termination clause that effectively said if the employee didn't report to work or provide a reasonable explanation for not reporting to work within 3 days, they would be deemed to be terminated. In this situation, the employee didn't provide sufficient medical information. And the background there is they had claimed that they had an undiagnosed illness. And so they kept going to various medical professionals, but were not able to provide the employer with the medical note that even confirmed they had a disability. They challenged the termination and alleged that it was discriminatory on the basis of disability. the HRTO dismissed the complaint because the employee that was terminated failed to provide sufficient medical information and sought to continue to be absent from work. And so this case is a good example of the obligations on employees to participate in the process and make sure that they are providing sufficient medical information. The other opportunity that an employer has to obtain medical is upon an employee's return from leave. So in those circumstances, an employer is entitled to sufficient medical information that outlines limitations and restrictions and also confirms their ability to safely return to work. Return from leave situations can often be complicated for employers, particularly where the employee has perhaps been out of the workplace for an extended period of time and it has suddenly requested a return. In those circumstances, it's just to sort of highlight this even further, it's within your right as an employer to ask for that confirming information if you suspect that it's been quite a bit of time since that employee has worked. Can that employee actually carry out the duties assigned to them? Information that confirms that is something that the employee can provide. But what the employer can't do is insist on a full recovery. So you can't deny an employee entry back into work simply because they've provided medical that indicates that they're not fully able to do their job and perhaps instead suggests a gradual return to work. That's where you gradually increase hours or increase scope of duties or decrease the number of rest periods. If that is a request that has been made by the employee and they've provided sufficient medical information to confirm the gradual return to work, that's something that an employer will need to consider in terms of whether that's something that can be accommodated. An example of that is the case referred to on this slide, Calgary Health Region and the AUPE. So this was a decision where the griever had a diagnosis of delusion disorder. The physician acknowledged upon their return to work that the griever had not been taking prescribed medication, but there was no major issue at the moment, and they needed to return to work because of financial challenges they were having as a result of not being able to work. And as a result, their medical professional suggested that the employee be given a gradual return to work. The hospital denied the return on the basis that the request to return for financial reasons was insufficient. The arbitrator determined that the employer's decision was not done in good faith and was deemed to be discriminatory, simply because the employee had provided a medical certificate stating that they would be permitted to go back to work on a graduated return to work plan. That was sufficient proof for an ability to return, and because the employer didn't provide any explanation for why the graduated return to work plan didn't work or didn't obtain additional information to understand whether the gradual return to work was something that could be provided, because they hadn't taken those steps, the employer was found to not have fulfilled their duty to accommodate. So we'll turn briefly now to terminations that may result from absenteeism that could be related to disability reasons. So the first step is looking at whether the absenteeism is culpable or non-culpable. So non-culpable absenteeism is what we will be focusing on today. And that's where someone is under a disability and can't control, or they've provided medical information that confirms that the conduct, that their inability to report to work, the conduct that's at issue is not related, or sorry, is completely related to the disability. And so in those circumstances, an employer can look to whether the absenteeism has gotten to such a rate that it's no longer feasible in their workplace. So some of those options are looking at deemed termination clauses and collective agreements, innocent absenteeism programs, and frustration of contract. And we'll talk about that in these three in the next few slides. So a deemed termination clause that typically comes up in a unionized environment, and it specifies that the employee would lose their job and it's under the collective agreement, they would lose their position if they do not attend at work or advise their employer of the reason for not attending, The absence by reason of illness or of an accident other than an industrial accident or occupational disease. Typically that's carved out because an employee who's absent due to a WSIB related injury will typically be permitted. The employer clearly has reasons for the employee's absence. In those circumstances, that deemed termination clause provides the employer with the right to consider the employment to have terminated. This still needs to comply with Human Rights Code reasons or obligations. So simply because an employee doesn't turn up doesn't mean that we can always take that step if we're, like to Jacob's comments earlier, if we're aware of an employee having perhaps an underlying disability that perhaps were there rumors in the workplace about it, we had some knowledge about it, or perhaps they've had issues in the past. There is an obligation on the employer there to at least do their part in terms of putting that information to the employee by simply asking sort of, is there any explanation, reasonable explanation for the absence? And then employers will often need to consider any information that they learn after the fact. So if the employee perhaps provides information after the fact demonstrating that the reasons for their absence were actually legitimate. So termination for absenteeism is an option in circumstances where the disability has gotten to a point where it's not possible for the employee to tolerate the level of absenteeism. So it's deemed innocent absenteeism under absentee management programs. And that's where an employer has created a program that looks at the average absences within their workforce or particular department, and then has tools in place to manage any employee who may exceed that threshold. And the program should clearly outline accommodation options, requests for updates, and then obligations for employees to provide information on the prognosis. The employer will need to demonstrate that they've reached a level of undue hardship when it comes to the level of absenteeism the employee is demonstrating. It's similar to the concept of frustration, which I'll talk about in the next slide, but for some employers, creating innocent attendance management programs is a good option to deal with high levels of the absenteeism that may be in particular departments or across the organization. So frustration of contract is where the employer has determined through information provided from the employee that there's no reasonable prospect of return to work in the foreseeable future. So the employee can't return to their job, and so the contract of employment is deemed to have been frustrated. You need to have clear medical information in order to make that determination, and that medical information needs to clearly state that the magic language is no prospect of reasonable return to work in the future. People have that sort of something more temporarily, like will be reassessed in a few months. That could be a situation where you can keep going back to the doctor to perhaps collect more definitive information, or perhaps look at a third-party review or an IME if that's appropriate. The frustration of contract assessment is different from the accommodating to a point of undue hardship. They're different legal tests, largely because the frustration of contract piece is tied to the medical evidence. So if you do have that clear medical evidence, that's a demonstration that the contract has been frustrated, whereas the accommodating to the point of undue hardship really looks at the employer's obligations around looking within its workforce to see how the employee can be accommodated. If you are considering, are in a situation where you are looking at frustration of contract, you still need to provide the individual with their termination and severance pay in accordance with the ESA, and you can't provide working notice. Okay, so I'll now turn to discussing some of the best practices around accommodating disability. We talked about some of the risks associated. We talked about what options an employer can use if they are in situations where they're managing high levels of the absenteeism. And now we'll focus on some of the key essentials points around accommodating workers in the workplace. So when we're looking at accommodating disability, we can think of it in 3 essential questions. So the first is, does the employee have a health condition that is recognized as a disability? And that's where the medical information I was discussing comes in, acquiring that medical information that accurately confirms that, and then also looking at sort of, are you in a situation where the duty to inquire has come up? And then the second point is looking at how does the health condition that the employee has impact their ability to work or their workplace conduct that may be subject to discipline. And that assessment also involves looking at the medical you've received and then looking at the responsibilities of the position. Can you change elements of the position? Or if you're dealing with workplace misconduct, is it a situation where the employee can't actually be disciplined because it's their underlying disability caused the conduct at issue? So the example of the absenteeism. And then you look at what can be done to facilitate the employee's ability to work. So undue hardship is the language that's used when we're talking about accommodation. So employers have the obligation to accommodate to the point of undue hardship, and there actually isn't a definition for undue hardship in the legislation. And what we typically say, it's a very difficult assessment. It will oftentimes require certainly high-level HR advice, but also in some circumstances, legal advice as well around, have we met the test for undue hardship? What's often helpful in determining what undue hardship is, looking at what undue hardship isn't. So what an employer doesn't need to do is create a job that doesn't exist in their workplace, and that's not required and doesn't provide any utility to them. But what they do need to do is what they don't need to do is ask other employees to accept unacceptable health risks. So if someone is being put into a position that they perhaps don't have the training for, and that impacts the health and safety of others, that's a factor that certainly should be considered. And you don't also have to ask other employees to tolerate excessive hardship as a result of the changed duties. So looking at them having to take on increased workloads, looking at whether they need to take on more overtime hours, those aren't factors that need to be considered. And you also don't have to accept an employee's failure to participate in the accommodation process. And we talked about that earlier. So you don't have to accept a situation where you're getting unhelpful medical or an employee isn't willing to even try the accommodation plan that has been provided. So when you are accommodating disability, you want to look at establishing the essential duties of the job that can obviously be set out in job descriptions, but some employers go a step further and have job demands analysis where they look in more detail around what the actual physical and cognitive abilities required in a role are. Consider the possible challenges. So that would be in light of the medical that you get. Understand that it's a shared understanding. So the process really does need to be open with the employee. Need to be conversation around what can in fact be suitable accommodation, how can responsibilities be changed. And it's also important to revisit and tweak any accommodation plans. And one way to do that a bit easier is to have written accommodation plans that expire on a particular date. And so, every 3 months you're looking at revising your accommodation plan, and that ensures you have accurate medical and updated medical information. And if the accommodation is causing kind of an impact on the rest of the workforce, it also gives you an opportunity to tweak anything that comes up. When it comes to accommodating disabilities, you'll need to plan for a relapse or setback, and that can come into place when we're talking about absenteeism, and as Jacob will talk about in the next few slides, can also factor in when we're talking about accommodating alcohol and drug abuse. Consider how you will respond to any new issues in the employee's condition, any changes in the employee's restrictions or prognosis, and any conflict that may arise. So if you're dealing with a situation around performance issues that come up when in the accommodation, there are strategies for addressing that, and an employer doesn't simply have to accept a level of performance in an accommodated role that may not meet their standards. So the accommodation strategies really are looking at any modifications to the job, any scheduling changes that can happen, any training that may need to be required in order to get an employee to perhaps take on a different role, and whether there needs to be changes in any supervision or management. So I'll now turn it over to Jacob.
Thanks, Samia. Okay, so we're going to spend a bit of time talking about addiction as a disability now. And addiction is becoming a more common disability in the workplace. So we'll spend a bit of time now just focusing on that in particular. So it's important to keep in mind that in this context, the duty to accommodate arises only where an employee has a disability under the Human Rights Code. And under the Human Rights Code, a disability includes drug and alcohol addiction. Generally speaking, there are three categories of workplace substance use. Recreational use, which may take place at work or outside of work, but have a residual effect such that the individual is impacted by the drug use while at work. Medicinal use, which may include marijuana or other prescriptions and medications, and use related to a substance use disorder. Now, the duty to accommodate will be impacted by the category of the individual's use, and what that will look like effectively may be impacted as well. So in the context of addiction, the duty to accommodate is most often triggered where an employee raises a drug or raises that they may have a drug or alcohol addiction. Now, an employee may identify or reveal such an addiction in a number of circumstances. And most frequently, we see this where an employee may indicate that he or she has an addiction in response to an employer identifying performance or attendance issues with the worker. For example, following a performance review or meeting with the employee. Another situation in which an addiction may be revealed is following a workplace accident. So as part of an investigation, you discover that the individual may have been under the influence of drugs or alcohol. And another situation is where an employee is suspected of being under the influence of alcohol or drugs in the workplace. And this may be identified by management or possibly by another employee as well. And as discussed earlier, as part of the duty to accommodate, an employer has a duty to inquire. So for example, if a worker tells the employer that he or she thinks that another worker is under the influence of alcohol in the workplace, the employer would then have a duty to inquire into this. So as mentioned earlier, an employer is entitled to sufficient medical information to satisfy the duty to accommodate. In the context of a disability, medical information may include any of the following. So confirmation that an employee has an addiction. An employee may withhold this information often due to stigma attached with addiction, or because he or she may have not even identified that they have an addiction. So this is where the duty to inquire becomes ultimately very important. So an employer will also want to understand the impact the drug addiction or the addiction disability, has on the employee's ability to perform the duties of the position. As well, the employer will want to know what the proposed treatment plan is. Does it include any inpatient treatment, after work treatment? Is the treatment plan being monitored by a physician, etc.? An employer does not need to tolerate an employee's continued use of drugs or alcohol or the impacts that it has in the workplace. Instead, accommodation requires an employee to commit to drug or alcohol treatment and for an employer to effectively assist with that process by providing time off as necessary for the treatment. So as part of the accommodation process, an employer may consider implementing what's known as a last chance agreement, which effectively says that this is your last chance to comply, and failure to do so will result in your termination of employment, for example. Now, this can be used where the misconduct would otherwise rise to termination or where the employee has been accommodated a number of cases, but has still had multiple relapses. When contemplating a last chance agreement for a disability, it's important to consider whether the terms of the agreement are reasonable. You also want to consider whether it's a unionized context and whether it really is the last chance. You don't want to say that it's the last chance when it is in fact not the last chance. So Stewart and Elk Valley Coal is an important decision on addiction and accommodation in the workplace. In this decision, the court upheld a termination of a drug-dependent employee for breaching a drug and alcohol policy. And an important element of this decision was that the employer had a clear and drug alcohol policy in the workplace, which the employee knew about and knowingly breached. So in this case, the employer had a policy requiring employees to disclose any dependence or addiction issues so that they could be offered treatment and accommodated and supported by the employer. The policy stated that if an employee failed to disclose and was involved in an incident at work and tested positive for drugs or alcohol, that they could be dismissed. This policy was known as the no free accident rule. The purpose of the policy was to promote safety in the workplace by encouraging employees with substance issues to come forward and to seek treatment and help before any issues occurred on site. All employees in this case had actually attended a training session where the policy was reviewed and explained to them. Now, Stewart was involved in an accident and he tested positive for drugs following the investigation. Following the accident, he then revealed to his employer that he thought he had a cocaine addiction and he was ultimately dismissed under the company's no free accident rule. Stewart's dismissal was likely upheld because of the policy that had been clearly communicated to all employees and allowed for the disclosure of addiction with treatment rather than with disciplinary consequences. It's also important to note that this decision took place in the context of a safety-sensitive workplace and where an accident could result in significant harm. This type of policy is likely not appropriate in all workplaces, and again, more so appropriate where there is potential for safety consequences. Now, this decision ultimately demonstrates that addiction does not mean an employee cannot meet the disclosure requirements necessary as part of the duty to accommodate, and demonstrates the importance of workplace policies and the role of an employee in the accommodation process. So that's our presentation on the topic of managing disabilities in the workplace. If anybody has any questions at this point, we'd be happy to address those.
That was a lot of information for everybody to retain. So probably everybody's kind of making their notes and trying to go over everything. Just so everybody knows, I am going to be sending out the presentation as well as the video link this morning to you. And if you don't have any questions, you can always contact Simia or Jacob later if something kind of pops up into your mind at that point. Does anybody have anything for them today? Or are we actually going to finish early? Wow. Okay. That's great. Thank you so much to Samia and Jacob, of course, for doing this for us again. Our next session in the series, I believe, is in September. Honestly, Samia, I can't remember which that one is about. Do you have that?
I don't have that on hand.
I don't have that on me either. Isn't that horrible? Thank you to Gord and Stephanie for sponsoring this event as well. So we do have 2 more events until we kind of break for the summer, other than golf. We have tomorrow, Kevin Rempel, who is a Paralympian medalist. He's going to be giving us an amazing motivational keynote. You can still register for that. And then we have our annual general meeting on June 11th. Thank you, everybody, for attending. Within the email I send you, it will have Samia and Jacob's email addresses if you need to contact them directly. Thank you.